Afternoon. This is the continued hearing before the Judicial Committee of the Privy Council of an appeal in Ciban Management Corporation against Citco BVI Limited and Tortola Corporation Company Limited. Mr. Hubble is continuing his submissions. Mr. Hubble.
Thanks very much, my lord. Can I first of all please just deal with two very short points that remain from questions raised by the council this morning. I've taken our instructions, and our understanding is in relation to accounts, which is a question asked by Lady Arden, that there isn't actually, or there wasn't an obligation to file annual accounts at the material time, and our understanding is that there were no accounts held by Citco BVI or TCCL. And the second point, my lady, was having checked the judgment at first instance, my lady is right that it does not expressly address red flags in the context of TCCL. Rather, at paragraph 65 on page 2136, the judge's conclusion that there was no duty at all owed either to undertake due diligence on the sale or to challenge the instructions.
Could I just raise one point with you arising from the first answer? The company what was set up to hold property, but was there any evidence that it received any rents, that it incurred any outgoings in looking after those properties, or was it simply a company to hold the title and left it to the Brazilian lawyer who'd been given power to do various things to look after the premises?
My understanding, my lord, is that it was simply to hold the property.
Not actually manage it in any way.
Certainly there's no evidence of any active management being undertaken by the company.
Thank you.
My lord, just before the short adjournment, we were looking at the limits of and exceptions to the geomatic principle. And can I invite the court's attention to the case of Bowthorpe Holdings, which is to be found at page 3128. And that is a judgment of Sir Andrew Morritt, Vice Chancellor, which considered the limits and exceptions to the geomatic principle. The background facts are a little complex. Y Limited was in effect a joint venture between B Limited, which was part of an investment trust group, and Y Limited, owned by two brothers, RH and PH, to operate an onshore investment management company, Argyle. PH, as the only shareholder in Y Limited, entered into an option agreement granting an option to B Limited to acquire his shares in Y Limited. The parties then fell out. PH, as director of Y Limited, endeavoured to transfer Y Limited shares in Argyle to his brother. And B Limited endeavoured to exercise the option agreement held over Y Limited shares. There was a first action in which B Limited sued PH for specific performance of the option agreement, which the court ordered. The representatives of B Limited then assumed control of Y Limited, and both companies then commenced action 3 against the two brothers, RH and PH, seeking rescission of the sale of the Argyle shares by Y Limited to RH and damages for breach of fiduciary or contractual duty or conspiracy. And the brothers, PH and RH, applied to strike out the claims against them on the basis of abusive relitigation, or that there was no reasonable prospect of success. And if we go to the holding, please, at 3130, alongside letter B, just below letter B on page 3130, the holding there states, furthermore, although a company was bound in an intra vares matter by the unanimous agreement of its shareholders, that principle would not validate PH's actions in his capacity as the only member of Y Limited, authorising the sale by Y Limited of its Argyle shares to RH if it was shown that the transaction was not bona fide or honest, was likely to jeopardize the company's solvency or cause loss to its creditors. And if we were to turn on, please, to page 3143 into the judgment of Sir Andrew Morritt, at letter B, there is a heading: does the claim of Yasawa, that's Y Limited, have reasonable prospects of success? And he identifies at letter C, because of the nature of the application, it being a strikeout application, that it is necessary to assume that YASA is correct in its assertion that the sale of shares in Argyle was an improper exercise of the powers of the directors, both because it was effected otherwise than in the interests of the IWASA and at a substantial undervalue. The submission is that even on that assumption, the claim must fail because the sale was authorised by all the shareholders in Yasawi. And then at paragraph 49, the judge cites various of the well-known authorities, including Solomon and Solomon, but and also cites multinational gas, which my learned friend places reliance on in his case, and concluding that in Solomon and Solomon, Lord Davey pointed out that a company is bound in matter intra vares by the unanimous agreement of its members. And then at paragraph 50, the judge says that by subsequent decisions, but subsequent decisions show that there are exceptions to such a principle. First, the transaction must be bona fide or honest. This, in my view, is demonstrated by the qualification of Viscount Haldane, an AG in Canada and Standard Trust, that the case was not a cloak under which a conspiracy to defraud was concealed. By younger LJ in Re-Express Engineering Works, that no fraud is alleged in respect of this transaction. By Lawson LJ in Multinational Gas versus Multinational Services, that the members must act in good faith. Thus in R. Geomatic Limited, Buckley J cited with approval the view of Asprey J in Parker and Cooper that the transaction must be both intra vares and honest. And in my submission, the question of whether the transaction is bona fide or honest, when it comes to bona fides, the question is what is the nature, or the question maybe what is the nature and purpose of what the member is doing, but one evaluates the transaction and whether the transaction is bona fide in the best interests by reference to the interests of the company. And one sees that at paragraph 55 in page 3144, where in dismissing the application to strike out, the judge says, but it is not necessary to go that far to dispose of the application. This is at letter H and I. The question for the purposes of CPR 3.42 and 24.2 is whether Yasawa has reasonable grounds for bringing in reasonable prospects of success in its claim to rescind the sale of the Argyle shares and or to obtain compensation from Peter Hills. The answer to those questions is plainly affirmative. If Yasawa establishes the allegations made in its particulars of claim, it will show that the sale of the Argyle shares was not effected for the purposes or benefit of Yasawa, but was a dishonest misapplication for the benefit of PH and RH. And so here, on the facts of our case, so far as the transaction was concerned, the transaction was not a bona fide or honest one for the benefit of the company, or so far as the company was concerned, because the purpose of this transaction was via, so we say, a sale at an undervalue, that Mr. Costa was going to get himself paid what he believed that he was owed by Mr. Byington. So the exception to the geomatic principle, one will often involve consideration of what the members' motives are, and if the members, for instance, are endeavouring to misappropriate assets of the company. But where one is looking at whether the transaction is honest and bona fide, I would submit that one addresses that from the viewpoint of the company and what's the purpose of the transaction from the perspective of the company. Here, of course, Mr. Byington wasn't actually acting in any way at all, because he didn't know about or assent to the request or instructions, and he didn't know about or assent to the transactions. And on that basis, my submission is that the geomatic principle shouldn't apply at all. But if it did, it would be illogical to attribute in some way the actions of Mr. Costa, but not then to attribute the bad faith and the actual underlying purpose of the transaction, so far as the company was concerned, which was that its assets were going to be sold off as an undervalue, and Mr. Costa was going to take his money. And so in my submission, quite apart from my first point, which is that this emphasizes that it's inapt to apply the geomatic principle in the context of ostensible authority. But in any event, when you look at what this transaction actually involved, it involves, it falls within an exception in geomatic because of the nature of the transaction, which was not honest or for the company's purposes. And further, in relation to attribution, I would submit that an instructive comparison exists between the findings of the courts below, and indeed the respondents' cases presented on this appeal, and the recent decision of the Supreme Court in Singularis Holdings and Daiwa. In my submission, the Court of Appeal in this case has effectively extended the geomatic principle so that the fraudulent request of an ostensible agent for documents to facilitate the sale of a property at an undervalue is to be treated as if it were the act of the company. However, in Singularis, if we look at 3447, please, page 3447, there the court was considering the question of attribution, including in the context of an illegality defence. But there the court was considering the dishonesty of, and one sees this from the first few lines of the holding on page 3447, the dishonesty of the actual 100% shareholder and the director and the president and the treasurer of the company. And the conclusion of the Supreme Court, as set out in the judgment of Baroness Hale, what was that dishonesty was not to be attributed to the company, as to do so would be to denude the duty owed by the banker of any value. And in my submission, it can't be the case that the dishonesty of 100% shareholder, the actual dishonesty of 100% shareholder, is not to be attributed to a company, because to do so would denude a quince-care duty owed by a banker of any value. But the dishonesty of someone who is said to be an ostensible agent of the shareholder, who is committing a fraud on the company, is to be attributed to the company, such that, in my submission, the duty owed by the director of the company would then be denuded of any value. So where one sees in Singularis that the dishonesty of the actual shareholder is not attributed to the company for the purposes for which one considers, namely, is there a relevant duty owed by the broker, it would be, in my submission, completely out of keeping with that approach to suggest that the dishonesty of an ostensible agent is in effect attributed to the company, because it is said that that instruction approves the transaction, with the result that the directors don't have to undertake any duties at all. And if one looks in the judgment of Baroness Hale at paragraph 38 at page 34, apologies. 3456, my apologies. And if we pick up the judgment of Baroness Hill, we see that here she's dealing with the question of attribution, and paragraph 28 identifies companies of being fictional persons, they have, of course, to act through the medium of real human beings. So the issue is when the acts and intentions of real human beings are being treated as the acts and intentions of the company. The classic exposition is to be found in the opinion of the Judicial Committee of the Privy Council in Meridian Global Funds Management Asia Limited and Securities Commission. And the Council will have in mind that that's the passage that is relied upon by my learned friend in his case. So Baroness Hill considers that classic exposition in relation to attribution to a company, but then goes on at paragraph 34 on page 3459 to say at the top of the page, at letter A, but in any event, in my view, the judge was correct also to say that there is no principle of law that in any proceedings where the company is suing a third party for breach of duty owed to it by that third party, the fraudulent conduct of a director is to be attributed to the company if it is a one-man company. And in her view, what emerged from Bilter was that they're referring to the trial judge, was that the answer to any question of whether to attribute the knowledge of the fraudulent director to the company is always to be found in consideration of the context and the purpose for which the attribution is relevant. And in relation to that case, the context was the breach by the company's investment bank and broker of its quince-care duty of care towards the company. The purpose of that duty was to protect the company against just that sort of misappropriation of its funds as took place here. And by definition, this is done by a trusted agent of the company who is authorized to withdraw its money from the account. And it was said that attribution there would denude the duty owed of any meaningful purpose. And Judge continued dealing with the Vex decision of Stone and Rolls in paragraph 36. And then in 37, alongside letter G, but companies are different from individuals. They have their own legal existence and personality, separate from that of any of the individuals who own or run them. The shareholders own the company. They do not own its assets. And a sole shareholder can steal from his own company. And in my submission, such reasoning in the context of attribution is equally, indeed more applicable to the instant appeal that the board is here concerned with, where the acts which in effect are to be attributed to the company are not those of the shareholder himself, but rather the instructions of a fraudulent ostensible agent. And to do so would certainly be to denude, not just as in singularis, duty owed by a banker, but would be to denude the actual director of the company of an obligation to take appropriate steps, such as to know the affairs of the business and to act on authorized instruction. And here, if Mr. Costa is an ostensible agent, well, that doesn't prevent, and certainly didn't prevent the analysis in singularis, that it would be wrong to attribute. And there was no suggestion in singularis that the answer to all of this was the geomatic principle or the multinational, what is termed the multinational gas point, but because the individual was a shareholder, that there simply was no question of considering what the obligation on the banker was. And in my submission, although I appreciate that singularis was a slightly different factual scenario, because it's looking at a duty owed by a banker, and there was some question in relation to possible insolvency, but the underlying principle must surely be that it would be an unwarranted extension of the geomatic principle if the acts of an ostensible agent in relation to a transaction which, through the eyes of the company, is not an honest one for its for its own best purposes, but to attribute that knowledge to the company is, in my submission, completely inconsistent with singularis. And so, if, first of all, to draw the threads together, if I'm correct in my submissions in relation to ostensible authority, either the existence of ostensible authority, the absence of reliance, and the failure of the respondents to be placed on inquiry, then this issue doesn't arise because the respondent simply had no basis acting on the instructions provided. But even if counsel was to be against me in relation to that, the approach of the courts below is an unwarranted extension to the geomatic principle, applying it to an ostensible agent and applying it in circumstances where the transaction is not for the benefit of the company. And so in my submission, operating on the basis of the findings of fact by the judge at first instance, nonetheless, both the judge and the Court of Appeal fell into error. My Lord, I think I may have overstayed my welcome by 5 minutes on the timings that were agreed, in which case I will of course deduct 5 minutes from the time for my reply.
Mr. Hubble, that was exactly what I was about to say to you that I was going to do. So Mr. Thompson has another 5 minutes eating into your reply tomorrow, should he need it. Thank you very much indeed.
I'm very grateful. Thank you, my Lord.
Mr. Thompson.
Lord Burrows has a question. I don't know if it's for me or Mr. Hubble.
For Mr. Hubble, actually, if I could just ask a question at this stage.
Yeah, yes, please do.
Yeah. Just going back to the previous powers of attorney, where we are, I think, clear that there has been actual authority given by Mr. Byington, albeit informal actual authority. Am I right in thinking that in relation to those powers of attorney, Spectacular couldn't have had an actionable claim for breach of duty against Citco, BVI and TCCL? In other words, because they were carrying out what they were actually authorised to carry out. Is that correct?
Yes, in those circumstances, but for the reasons I've explained, I hope that we submit that the position of Mr. Costa in 2001 was very different in relation to the fifth power of attorney.
Yes, certainly, but it just means that a lot of what you said about they ought to have done this, they ought to have done that in the earlier scenarios isn't entirely accurate, I would suggest to you, because if they were just carrying out what they were actually authorised to do, they couldn't be regarded as being in breach of duty for doing that.
Well, it's what I do say is that what they should have done on the face of their files and their obligations is that they should have checked that Mr. Costa did in fact have the authority of Mr. Byington. As I've explained, on the files, Mr. Stallman was identified as the correspondent, and Mr. Costa wasn't identified as having any status or authority to act on behalf of Mr. Byington. So I would say that they should have checked in their capacity as director or registered agent. They didn't, and in that sense, they may have taken a risk in relation to the transaction. As it happened, in relation to those transactions, Mr. Costa had the actual authority of Mr. Byington.
And therefore no breach of duty.
And therefore no breach of duty. But I don't say that there wasn't an obligation on them to have checked and queried because it was inconsistent with their files.
Thank you very much.
Thank you. Mr. Thompson, I think you've got almost 10 minutes extra to play with should you need it.
I'm very grateful, my lords and my ladies. Before I address the substantive legal points and legal arguments which my learned friend has made in the course of his submissions, I just wanted to go back over 2 points of fact that in my submission it really isn't open to Mr. Hubble to address today, either because they have been determined definitively by Justice Bannister and the Court of Appeal, or because they were never part of the case at all. And those 2 points are, firstly, the involvement of Mr. Costa in the setup and operation of Spectacular, and what Mr. Hubble presented to you about that in connection with the relationship between, on the one hand, Mr. Byington as the UBO, and on the other hand, the respondents as the registered agent and director of the company. The second point I want to address is the point which is taking up an increasing part of Mr. Hubble's case, which is this suggestion that this case is about a fraud perpetrated by Mr. Costa upon Mr. Byington and the company. And for reasons I will come to demonstrate, that is not the case that was run or pleaded. It is something Mr. Byington said in his evidence, but it was patently not proven on the evidence, and certainly not found as a matter of fact by the judge. And that point, the fact that fraud is not an element of this case, undercuts an awful lot of what Mr. Hubble says when he comes to his submissions on the law. So I'll address, if I may, those 2 points first. I ought to just say, by way of introduction, that I'm going to make oral submissions limited just to answering Milena Friend's submissions. You obviously have my case, which ranges over other points that I will take as read in the usual way. So, my lords, if I can just deal with the setup of Spectacular, it's important to understand, and at the risk of taking your lordships and ladyships over some documents you've seen before, the nature of the setup of Spectacular and the role which Mr. Costa played in that from the beginning. And I want to do that by reference to documents in October and November 1997. And if you can turn first then to page 1276 of the record. This is one of the earliest documents in the record, and your lordships will bear in mind that we are trailing back here. Even at the time of trial, we were going back 15 years. Now we're going back 23 years. One point I will make before we look at these is that the nature of communications, particularly by email, was very different in 1997 from now. I don't think I had, and your lords and ladyships will all have been working at that time. I don't think I had a work email at that time, and I was at work. And I think a lot of people operated emails a lot less formally than they did today. But that's just an aside. If you look at 1276, you can see a fax from Mr. Costa to Mr. Van Alst, October the 27th, 1997. And you can see from that, from bundle C, that it was clear from the beginning that Spectacular was going to have Mr. Byington as its beneficial owner, its ultimate beneficial owner. That's clear from this, one of the very first documents in the case. If you go over the page to 1277 then, you can see that this fax, which was sent then from Mr. Van Alst in New York to Humphrey Louis in the BVI, so it's a Citco to Citco fax, if I can call it that, identifies about 3/4 of the way down the page that Mr. Albert Jackson Byington Netto is, well, it doesn't say he's the beneficial owner, but it says here there has to be a management agreement prepared with him. It also asks for the attached power of attorney to be prepared. This is the same day. Then go forward, please, to page 1279, and you can see the management agreement, which no doubt was attached to that fax. The management agreement at 1279, and there are 2 copies of this, and this is the first one, has Mr. Byington identified in the first recital as the beneficial owner by name. Can I just point out, as we pass over this document, clause 4, which said that Tortola is going to assign its right to charge for its services as director to Citco. Now, obviously, that was something Tortola had the right to do with or without Mr. Byington's consent. There might have been issues about whether Mr. Byington or anybody else could get good receipt for paying for those charges if it paid Tortola or Citco if it hadn't had notice of that. Those are questions that weren't explored, but patently the assignment of a right to charge for services is something which was in the gift of Tortola to do. The second version of this document is at page 1282, but I will pass over it if I may, because although it's dated the same day, as I'll show you, it was actually produced in November. So the document I want to go to next is 1290, which is 2 days later, underscoring the point that Mr. Costa was telling Mr. Van Aalst again that Mr. Byington was the beneficial owner. There can be no question then that Mr. Van Aalst knew who the beneficial owner of this company was going to be. He'd been told it at least twice now. Then go forward to page 1298, please. Here is Mr. Byington's Floridan lawyer, Mr. Stallman, and you'll see references to Mr. Stallman. Norman is Mark's father. They are a father and son firm in Boca Raton in Florida. And you can see that they confirm they've known Mr. Byington for a number of years and he's in good standing. It's patently in connection with the formation of Spectacular. You can tell from the date and the wording of that. The following page is a document Malone and Friend took you to, headed a blocking certificate, but really just demonstrating the fact that it is going to be Mr. Stallman, the son, who holds the bearer share certificates of Spectacular, but for Mr. Byington. Again, he is expressly named there. Then go forward, please, to page 1308. This document you were taken to by Malone and Friend, but now in context, you can see just a few days later, it's November the 10th, so it's maybe a fortnight later, this document identifies the company name, and the name feeder is Mark Stallman. This is about a third of the way down in handwriting, who is a Citco client. Feeder was referred by is Citco client. The activities of the company, there's a very short point here, which probably has little significance, but I did want to pick up on. The activities of the company are identified as real estate, and over on page 1309, Mr. Byington identified as the beneficial owner again. But if you look at 1310, Malone and Friend said the activities of the company were identified as holding and real estate. I'm not sure that you can deduce that from this form, because as you can see from the words in that follow the first full line, the words yes, no are lined up in 2 columns for consulting, licensing, management, trading, real estate, but not for financing. And it looks simply as if somebody has misformatted this document, and holding really ought to be directly above the word consulting and financing directly above licensing. If that is right, yes, no has only been scribbled out on real estate. It's not a big point, and the judge said, and as is clear, that the business of the company was holding real estate, and it's not really a dispute about that, but the documents do not show that it was to hold real estate. The documents show its activity was real estate. It might have some significance in relation to Section 80 if we need to consider that. And it is completed, this form.
Mr. Thompson, are you saying that, properly understood, the document would have said holding company, financing company, consulting company, etc., and what it should be construed as just saying real estate company?
Yes. I mean, I don't want to take too much away from this document, simply to say that because of its layout, it would be, I think, unsafe to conclude that this document indicated that the company was involved in holding real estate, as opposed to just having or dealing in real estate. It's a point that may have very, very little difference. And as I say, the first instance judge did in fact find that the company was in the business of holding real estate. The significance only comes in, my lord, in relation to the question of what the usual activities and usual business of the company were under Section 80, which, as I'll demonstrate, is only one of a number of points why the Section 80 argument is bad. And in any event, as I say in the case, it's an academic question in the first place. So, my lord,
I don't think in any event either party is asking the board to make new findings of fact. You're simply wanting to present the findings of fact in a context.
That's right, my lord. But and it is the most minor, and your lordship may just tell me that I'm wasting time, but it was the most minor correction that I wanted to make of Mr. Hubble, who had suggested this form said that, and I don't think it does. If I can go forward, my lord, on page 1316, still in November 1997, I'm going to pick up this point about the management agreement, and it answers, I think, one of my Lord Legate's questions from this morning to see what happened with this management agreement, because the first thing that happened is that Citco BVI invited Mr. Stallman to really to get this management agreement signed. It doesn't say it in terms, but it's partially signed, and they asked for a fully executed copy to be returned for us for our files. Well, as you can see from looking at it, and it starts at page, this fact has been lost from its attachment because the KYC follows. But if you go forward to page 1318, you can see what was almost certainly the reply, because it's 4 days later, from Mr. Stallman, sent to New York rather than the BVI. But Mr. Stallman says, as we discussed, presumably by phone, please find following my suggestions for the management agreement. Please forward new copies for execution at your convenience. Please also remember to send a copy of the latest invoice to Henriquez, Mr. Costa. And then the copy you can see at page 1319. Now, what you can see here is a management agreement that's slightly different from the one I showed you before. Well, it's the same as the one I passed over, but this one has scribbles on it. And now, rather than identifying Mr. Byington as the beneficial owner, it says in the typed version, at least, Stallman on behalf of, for and on behalf of Mr. Byington. And Mr. Stallman corrects it to say, as US attorney for the beneficial owner. So Mr. Stallman has excised Mr. Byington's name and identified himself as an attorney, but otherwise left that draft the same. That document still wasn't signed by anybody. You look on page 1320. Mr. Stallman didn't sign it, no doubt hoping that it would be redrafted, typed up. If you then look at page 1321, this is probably the preceding email that asks Mr. Costa, are you aware of this management agreement? And secondly, it provides only for my signature, Mr. Stallman says, but I do not think that is accurate. As far as I know, I'm not a signatory or officer, just the custodian. So this probably predates the corrected or the revised draft, the handwritten revision that Mr. Stallman sent back to Mr. Van Alst. In any event, you can see on page 1322 a fax header from Mr. Van Alst, which appears to be sent to the BVI. It says attention of Citco BVI in the attention line, but doesn't have the company or number on it. PTNA, which I think stands in this chain for please take all necessary action and send the new management agreement to us by pouch. But look at the words in handwriting, which I try and decipher. They say beneficial owner's name should appear in the management agreement. Reiterate the fact that this is a confidential document between only Citco and the company and him, and will not form part of the publicly held info or be disclosed to any third party. So somebody has thought fit to write on this document a note to encourage, no doubt, Mr. Byington to sign this document with his name on it. As we know, it wasn't signed. You can see at page 1323, I think the last fax in this chain, where Citco BVI is inviting Mr. Stallman to get the management agreement signed off and executed. That, as we know, never happened. The suggestion then that Mr. Van Alst, in an email that Mr. Hubble took you to, might have been so confused as to think that Mr. Costa was the client is hard to credit. He is intimately involved in this exchange, passing messages backwards and forwards between Mr. Stallman, Mr. Costa on the one hand, and Citco BVI on the other. He's the linchpin for this initial discussions about the setup of the company and the management agreement. The email Mr. Hubble relied on is at 1332, and it's sent admittedly a few months later, but it's April 1998. That's the last email in the chain on page 1332. 2 days ago, we have sent you, I should say this is to the BVI, a request for a power of attorney for the above company. The client called me today to let me know there was a mistake in this document. He will send a new POA. And to put this into context, this is the second power of attorney. The first one was duly executed when the company was incorporated. So the second power of attorney, Mr. Van Alst is saying there's been a mistake in the document. And he says the client called me. And from that and the subsequent document, Mr. Hubble invited you to conclude that Mr. Van Alst thought the client was Mr. Costa. That's because the next document at 1333 is from Mr. Costa to Mr. Van Alst, and it has the text of a power of attorney, and it says in handwriting at the bottom, please disregard my previous facts. But that's not a safe inference to draw either. It's quite possible, of course, looking at 1332, that it was in fact Mr. Byington that called Mr. Van Alst to say there was a mistake in the document. He will send us a new POA. Maybe then Mr. Costa sent it. That's one possibility. Another possibility is simply that Mr. Van Alst didn't think it particularly important whether the BVI were told that it was Mr. Byington or Mr. Costa who were the client here. For all intents and purposes, this is an exercise in getting a power of attorney signed off. Mr. Van Alst has no doubt that Mr. Costa is authorised to do that. And this is simply a short email inviting them, or maybe asking them to hold off till the new one comes through, but asking them to execute the client's instructions. Whether that's Mr. Costa or Mr. Byington matters very little in the execution of these instructions. Then to finish this part of my submission on the facts, I just wanted to show you that Mr. Costa had continuous involvement with both Citco BVI and Citco New York at every other point when Citco BVI was in fact involved. In fact, at every other point when Spectacular did anything at all. So if you go through to page 1350, this is in the context then of the well, it's an invoice, I think, following the second power of attorney. You can see that it is Citco BVI who send the invoice to Mr. Costa for Spectacular. That's June 1998, and the invoice follows. If you go to page 1352, the next month, July 1998, Mr. Costa, again, faxing Humphrey Liu and copying in Eric Van Alst in New York. So those two numbers, 284, that's the Tortola, 212, that's New York. So this is Mr. Costa telling them both, faxing them both, to ask them for correspondence to be sent to him at that address. That address is the address of the property that was sold, I believe. If you then go forward to 1366, you can see now the following year, August 1999, Citco BVI. These have been copied so many times, they're getting a bit smudged, but you can see Citco BVI, Mr. Abdulatif, faxing Mr. Costa. This is to advise you of former account representative at Citco BVI, Mr. Humphrey Lee, has left our employment. Then 1376, exchanges in early 2000 between Mr. Costa and Mr. Abdulatif. I think you were shown this by my learned friend, talking about the payment of certain invoices. It's Mr. Costa who's affecting those payments. And then finally at 1377, sorry, I think 1377 is the email my learned friend took you to. Now in April, further emails about the settlement of invoices. Now, just to put this into context, in the trial back in 2012, Mr. Byington sought to present Mr. Costa as a mere amanuensis. You can see that from the judgment of Justice Bannister. And he sought to present him as a sort of clerk who he trusted to do basic administrative functions, but not anything important. And Justice Bannister, as you will have seen, completely rejected that for obvious reasons. There's correspondence that I'll touch upon in due course that shows their relationship was very different from that. And Mr. Costa, who was very senior at this time, was in fact, if not a business partner, was certainly a sort of right-hand man who helped Mr. Byington in all aspects of his business, up to and including management. But in any event, there can be no question but that Mr. Costa was the point person who was expected to deal with the BVI companies. The list of them's there on 1377, but in particular, Spectacular. Indeed, it was he who was instrumental in having the company not incorporated, certainly acquired on behalf of Mr. Byington. And it's he that arranges the payment of all the fees, and it is he that is involved with all the powers of attorney from first through to fifth. The powers of attorney, can I just take you to the powers of attorney again at the risk of repeating matters, but just to underscore Mr. Costa's involvement. And so I'm going to go back in time and in the bundle, if I may, but if you pick it up at 1283, 1283, that's the wrong page, 1285. 1285 is the first power of attorney. Two points I want to make about the powers of attorney as we look at them. Firstly is the width of the powers on their face. And again, I should say that at trial, Mr. Byington sought to suggest that whatever they said on their face, the first to fourth powers of attorney were extremely limited. That was certainly not accepted by the judge. And you can see on the face of it that it's just not a viable point for him to make. The second point I want to make about the powers of attorney is the fact that Mr. Costa was involved with all of them. The first one, it barely needs repeating because you've seen all the surrounding documents, but just to look at its terms though, at 1283, you can see that 1285, you can see that this is a power of attorney to deal with GEL. So it's the final sentence of the main paragraph. This power of attorney is granted with the specific purpose of undertaking legal procedures against the company GEL. That's what it's called. And as the judge found in the earliest paragraphs of his judgment, this was just this fraud perpetrated by Mr. Byington on the revenue to try and extract the only real valuable asset of GEL from the hands of its creditors and to place it safely in a BVI company where it couldn't be got at by the tax or other creditors of it. That was something, as the judge found, that Mr. Byington was remarkably open in admitting in the course of cross-examination, but certainly wasn't clear in his witness statement or on any of the other papers. The second power of attorney is at 1337. And this power of attorney is in exceptionally wide terms. Well, firstly, I should point out it's to Mr. DeLollo now. The first one was Mr. Valente. This is Mr. DeLollo, but he is a lawyer, as it says in the text of the power of attorney, in Sao Paulo. And the power of attorney is so he may represent the grantor, I'm picking it up 3 lines down after Mr. DeLollo's name, actively and passively, with full powers of the ad justitia et extra clause, before any kind of judicial proceedings, appeal any decision, make agreements, compromise, desist, pay and receive payment and grant release, and take all the necessary measures for the due representation of spectacular holdings in Brazil. So there's no restriction there to deal with any particular proceedings or any particular property. It's a very wide power of attorney. That's the May 1998 one. Then, if you will, go forward to page 1356, which is the third power of attorney, again to Mr. DeLollo. It's October 1998 again. It is, I believe, in identical terms of its width. Again, if you look at the paragraph immediately following Mr. DeLollo's name, make agreements, compromise, desist, pay and receive payment, grant release, take all necessary measures for the representation of the company. And the fourth one is at 1369. Which is a limited one now. This one is sorry, just yes. So this one under the powers, again to Mr. DeLollo, is granted powers to represent it, the company, in all corporate acts that will be registered on the Junta Comercial del Estado de Sao Paulo, JUNCSB, related to the incorporation of the company named Guaraná Participação de Negócios Limitada. Now, so this is a limited power of attorney because it was intended just to deal with the incorporation of a Brazilian company. In fact, what Mr. Byington said was that never happened, but that is limited. So the fact is the second and third powers of attorney were in almost unlimited range of powers. The second, third, and fourth were all to Mr. DeLollo. Then, if you look at the power of attorney in question, which is at 1428, it's at various places, but 142. Now, I'm going to get the page wrong again, I'm afraid. It's 1426. At 1426, you can see the fifth power of attorney, the 15th of August 2001, again to Mr. DeLollo, and this is now actually more limited, certainly than the second and third power of attorney, because it is only specific powers to cause the sale and sell on behalf of the grantor its real estate properties at 1, 2, 3, 4, 5. So on the face of it, the fifth power of attorney is actually more limited than at least the second and third power of attorney. And as a matter of fact, it's more limited than the first power of attorney because the first power of attorney was really just to extract all these properties in the first place. If you like, it's the mirror image, but that's only if you know everything there is to know about the company.
Mr. Thompson, would the second and third powers of attorney have remained in force throughout this time?
Yes.
No.
As far as we know, they were. And there's a document which I might struggle to identify the page number of, but there is a document sent after the bloom went up in, I think, early 2002 for a Mr. Stallman or possibly Mr. Green in Florida, who directed that all the powers of attorney be cancelled. And so the suggestion is that at least there was a risk that they hadn't been terminated prior to that.
The arrangement appears to be that Spectacular simply holds the title to the property, and Spectacular has given Mr. DeLollo power to do whatever needs to be done in relation to Spectacular in Brazil.
Well, that's right, my lord. And one of the points I make in support of my submissions is that these powers of attorneys were always granted to lawyers, and lawyers who were in the same city as the ultimate beneficial owner of the company. So the expectation, no doubt, would have been, if you'd asked the directors of the company and the BVI at the time, that these powers of attorneys were going to be utilised for whatever purposes the UBO required them to be exercised for, under his more close supervision in his own hometown.
Thank you.
I'm just seeing, my lord, if I can quickly, in answer to your question, identify that document I just told you about. The answer is I can't. So let me move on. I'll find that over.
Before you move on, please, on 1426, the fifth power of attorney, nothing at all is said about what is to happen to the proceeds of sale, if there are any.
Yes. Well, my lady, yes, no, that is obviously the case. As I said in answer to my Lord Hodge, these powers of attorneys were all granted to lawyers, with no doubt whatever professional obligations they have under their own systems, and with the expectation, certainly it would have been a reasonable expectation, that the lawyers would have only been doing those things that they were told to do by their client. And the client, no doubt, would be the same client as Citco had.
But how do you know whether the client is going to account to Spectacular or not? The client may be intending to hand it to charity.
Well, my lady, it is, of course, one of the oddities of many of these companies that hold companies like that hold assets like this, that very often the consideration doesn't pass one way or the other. I mean, you'll recall that at the inception of this relationship, without my clients knowing anything about it, Spectacular, under the first power of attorney, became the owner of these properties. But there wasn't any financial consideration passing from Spectacular for the acquisition of those properties that was notified to the BVI. So they came into under the umbrella of Spectacular, and they went out of the umbrella of Spectacular without any consideration.
Yes, well, inflow is one thing, but outflow is quite another, because these are directors. We're talking about TCCL's duties as a director. They have responsibility in relation to the assets and their application.
Well, my lady, I understand that point, and I'll address that, if I may, when I come to deal with the multinational gas point.
Lord Leggett has a question for you, Mr. Thompson.
I just want to understand how far you're going on your submission, Mr. Thompson, about the width of the second and third powers of attorney. Are you suggesting that the fifth power of attorney wasn't needed at all, and that Mr. DeLollo was already authorised to do everything he did, or do you accept that it was in fact needed?
My lord, I'm not going so far as to say that it wasn't needed. That would be as much a matter of Brazilian property law as anything else, and I'm particularly underqualified to express any view on that. Or the only point I make about it, and my submission is limited to this, is that on its face, this isn't a power of attorney of exceptional width.
Right, thank you.
My lords and ladies, that addresses all I wanted to say on the facts about the relationship of Mr. Costa in the general scheme of things from the October 1997 through to the time of the fifth power of attorney. I wanted to address, as I indicated at the beginning of my submissions, this suggestion which now underscores a lot of what my learned friend says about the whole actions of Mr. Costa being a fraud. There are a few things that it's very important in my submission to bear in mind here, and they're all under the heading, this is not a fraud case. Firstly, it was not proven that the sale value of the property was an undervalue. It was repeatedly said by Mr. Byington, and he did complain about it, and he complained about it in Brazil as well. But he adduced absolutely no evidence to support the idea that the property was sold at an undervalue, and he adduced absolutely no evidence to support the idea that Mr. Law, the purchaser, was anything other than an arm's length purchaser. It would have been open, obviously, to Mr. Byington to adduce that evidence. It would have had it in his power, and your lordships and ladyships would have seen that actually there were extensive and lengthy proceedings in Brazil to get the transaction overturned, and there was then an opportunity given to Mr. Byington to resell the property, and if he had done that at a higher value, then all the loss that he might have otherwise said he'd suffered would have been recouped that way, subject possibly to legal fees. He would have got back everything that he said was wrong. As your lordships have seen, the question of quantum is an open one, which if I fail today and I fail on the indemnity point, well, they don't have to go back to court. But at this moment, there has been no evidence put before the court that the sale was an undervalue. There has also been no evidence that it was in fact a fraud, and that's not the way the case was pleaded or run at trial. Can I take you quickly to the pleading to make good that point? And you can see how it was actually pleaded. I think it's the third re-amended statement of claim is at page 2197 of the record. And you can see after the sections dealing with the defendants at page 2198 and the duties at 2199 and following, the critical sections at page 2202 dealing with the unauthorised sale of the relevant property. I'm not going to take you through each paragraph line by line. I'm just going to tell you, and if you'll take it from me, so Mr. Hubble tries to correct me, there is no pleading of fraud in this case. What there is a pleading starting at the bottom of page 2202 that the sale was unauthorised. And the accusation, the highest accusation gets is to say, firstly, that Mr. Costa's sale was unauthorised. Well, that's not in dispute and wasn't disputed at the trial. But also then at 2209, that Mr. DeLollo defrauded spectacular. That's at paragraph 5.3, Roman 3, at page 2209. And all that is, paragraph 5.3, is a recitation of the claim that was brought in Brazil, that the injunction, the quiet title action to stop the conveyancing of the property to the putative purchaser, Mr. Law. And the injunction was based upon, amongst other things, Roman 3, Spectacular's allegation that it had been defrauded by Mr. DeLollo and others. It doesn't say Mr. Costa, even though, as you can see from 5.1, that Mr. Costa was in fact a party to this action. Now, Mr. Byington didn't call Mr. Costa. Now, you may say, well, that's not surprising. My client sought to, but it's difficult sometimes to get people from abroad to attend trials where they might be accused of doing things without authority. But in any event, the evidence that was before the trial judge was, and the case that was before the trial judge was not that Mr. Costa had defrauded Spectacular, but at its very highest, he had done something unauthorised, and Mr. Lollo, it was said in passing, had defrauded the company. The Brazilian proceedings were settled not once but twice, because Mr. Byington didn't abide with the initial settlement agreement, so there were subsequent proceedings and he settled those as well. They didn't result in any outcome as far as anyone was told at trial or subsequently, and so there's been no determination of whether there was a fraud or not, or indeed how the fraud was alleged and prosecuted against Mr. Costa. It is obviously the case, and anticipating your Lordship's questions, it is obviously the case, and I accept that this was not, in fact, a power of attorney whose grant was authorised by Mr. Byington. It is obviously the case that Mr. Costa wasn't actually authorised to do that. But it may well be the case, and it would be dangerous to infer otherwise, that Mr. Costa thought he was authorised, or at least thought he was acting in the best interest of the company. Let me show you a page which you haven't been shown, which supports that submission of mine, at page 2056. Now, just to put this into context, this is a handwritten document which was extracted, I think I'm right in saying, from the Brazilian proceedings, and it is from Mr. Costa to Mr. Byington, and it's obvious from its face that this is the first document or the first notification that Mr. Byington had of the sale of the property. You can identify its timing quite clearly. It's also
page number again. I'm so sorry.
Sorry, 2056, my lord. 2056.
56.
2056.
And you say it's handwritten.
Well, it was handwritten. It's been transcribed.
Thank you.
It's possibly been translated and transcribed.
Thank you.
But what this is, and I submit this is obvious once you read it, is the email, the response to which was, Mr. Byington, you must be joking, and it's a very bad joke. So Alberto, Mr. Costa writes, having finally succeeded in finding a buyer interested in the Avenue do Estado building, today the 5 records belonging to Spectacular were sold. The remaining record which the buyers wish to rent remains under the control of GEL. So that identifies the time pretty precisely. It's almost certainly then the 14th of December 2001. The value there is put at 1.15 million reals, and the first installment of 50% has already been paid. And you can see there he talks about the second payment being paid when the building is delivered, completely unoccupied, not more than 60 days from now. And then the balance statement, if you look at the paragraph 6, you can see that Mr. Costa does an accounting exercise, says that the first instalment of 575,000 reals has been paid. There's minus a payment of IPTU, that must be tax of some kind, I assume, fees to Mr. Zalolo, the financial settlement to himself, that's 316,000 odd, leaving a very, very small balance, and the second instalment to be received, which will mean the final balance is 577,000 odd. I await your instructions for the destination of these balances. So, and over the page at 2057, Mr. Costa has produced a table detailing the settlement. Now, there was a settlement agreement, and this purports to work out the amount due to Mr. Costa in the bottom right-hand cell, 316,000, which is the figure that's carried back to the preceding page. So, a few things to say about this communication. The first is If this was a fraud case, it would be a bit peculiar to find the fraudster emailing before the time of completion, certainly before the time of the second payment of the instalment, to the defrauded victim to tell him not just what he's done, but also the financial details of how much he's taken, which is not all of it, and asking him for instructions on what to do with the balance. So if it had been a fraud case, this would have been a document that Mr. Byington would have had to answer. But more importantly, for present purposes, what this document suggests is that Mr. Costa didn't think what he was doing was underhand. He might not have thought he was specifically authorised, and no doubt what my learned friend will say in response is, why was there nothing said between August and December, between the power of attorney being granted and the sale being completed? Nobody will know the answer to that question. They may or may not have been talking to each other. They were, it seems from various emails, quite friendly, and I'll take you to those in a second. But Mr. Costa obviously thought he was doing the right thing, or rather, he thought he was settling off debts, and he thought he needed to account for the balance to the person he knew was the beneficial owner. So it's far from the case that this was the actions of an underhand crook trying to defraud his principal or the company. And in that vein...
Just a moment, sorry. Have we seen any evidence about who received this document, what happened next, and all the rest of it? Because it's very difficult to just look at a piece of paper in the abstract. I've not seen any finding of the judge, as I recall.
My lady, it was 12 years ago, and I will need to check the transcript, but I am almost certain I put that to Mr. Byington and asked him about it. But it was in that context of the bombshell, I think Justice Bannister describes it, where the response is, "You must be joking." I don't know. I'll check the record in more detail overnight, my lady.
Was this before? I'm so sorry. I didn't mean to cut you off.
No.
I just wanted to know whether Mr. Justice Bannister had the opportunity of considering this, and whether the Court of Appeal had it.
This record is the identical record that was before the judge and the Court of Appeal. So this document is not fresh, and you can see from the bottom of page 809 written on. That's the original trial bundle number. And as I say, my lady, though, we do have the transcript, believe it or not, at least of some of the trial. I believe Mr. Hubble may even recollect that this was a document which was taken, which Mr. Byington was shown.
Thank you. Thank you.
But my lady, my lords, it's worth just pointing out.
Thompson, you can certainly say that there was no finding of fraud by Mr. Justice Bannister. But he did, I think, describe what Mr. Costa had done as a betrayal.
He did. He absolutely did. And obviously, I'm not seeking to undermine the factual findings of the judge either. One can quite understand that in the context where Mr. Byington obviously didn't want this done, and his immediate reaction demonstrates that could be seen as a betrayal. But that's not the same thing as somebody defrauding you. If somebody does something which you don't like, it may or may not be a fraud, depending on, apart from anything else, their own state of mind. But my lord, the point I'm making really in this context, and I'll just take you to three more communications between Mr. Byington and Mr. Costa, is that it is wrong for Mr. Hubble to suggest, as he did almost sub silentio here, that Mr. Costa was creeping around in an underhand manner and trying to extract some benefit. Those are the facts of most of the cases that Mr. Hubble likes to rely on, where directors or others seek to defraud the companies or their principals. This was just not that case. And just to make good that submission, I wanted to show you four communications three communications that post-date the termination letter, because you might have been left with the impression from listening to Mr. Hubble that after November 2000, Mr. Costa disappeared into the ether, was released, and then simply used powers that he had left over from before to defraud Mr. Byington. That patently isn't the case. If I can take you first then to the resignation letter, which is in the bundle at 1378, or if you don't speak Portuguese, 1379. And the translation, it shows you this is an irrevocable resignation from this organisation, although neither in the original nor on this can you see what the organisation is. But the point I want to make is that despite this resignation from the organisation in November 2000, for many months later, well into 2001, Mr. Costa and Mr. Byington were discussing with each other matters of business, including matters relating to Spectacular. And for that, can I ask you to turn to 3 pages starting at 1400, and again, anticipating what my Lady Arden might ask me, yes, these were all before the judge and run through in the course of the trial. They are transcriptions and I think translations of handwritten notes, but you can see first one is sorry, I think they say handwritten. Some of them look like emails, but there we go. 21st of March 2001, from Mr. Costa to Mr. Byington, talking about their recent past, giving hugs to each other, talking about their families, but also talking, as you can see, about money, and not insignificant amounts of money. And if you look at the penultimate paragraph on the page, after the words "on another subject," as agreed, I requested that Citco dismiss the companies Polar Sky and Xenox, but they are charging fees to Waterloo, which is the shareholder of GEL, and Spectacular, which is the owner of the building, in the total amount of $2,040, according to invoices which I'll also deliver to Luca. Additionally, they're charging through Norman Stolman the fees for Devonwood and Worldwide. I think we can also let go of these. I will try with Ansano to obtain the 2040, but money is tight. See what you can get over there. And the context is that Mr. Byington was in Paraguay around this time. And you can see then the next emails, which are slightly out of order, if you pick it up at 1403, in April 2001, Mr. Byington replies to Mr. Costa, "I hope you've had a good Easter despite this earthquake we're going through." All kinds of discussions about the operations of their business, which I won't go through in detail. And that email or letter, it would seem, continues on the preceding page, 1402. And all kinds of details about the operation of the business, which I'm not going to go through in detail. And at the end of it, just 2 paragraphs in the end, I'm thinking that within 3 weeks, I'll be able to jump over to SP, presumably Sao Paulo, more easily, and then we can speak more calmly with more details for you to be able to relax more. Meanwhile, I can say that while everything is going well and solidifying with apparently a lot of security, what I still can't is quantify more objectively. Warm regards to you and Clarice. And then the final one I want you to look at is 1404, which is again from Mr. Byington to Mr. Costa, now May 2001. Still all these problems that they're having with their various companies, clearly talking about business. And importantly, at 1405, you can see about halfway down the page, I don't know, sorry, can I start at the paragraph before that? I think that we should have closed the majority of the companies abroad, and I'm not very willing to use my old traditional one because the balance is very low. They've already warned me that they wanted to close this account, which I don't really want. I don't know if Norman's son, that's no doubt Mark Stolman, still has some company available, or if Spectacular would be willing to do it. I don't have the least idea of where Spectacular is located. Please do me the favour of thinking about this problem and suggesting a solution. Implementation of this should be quick because we intend to have the operation live within 20 days. So as late as May 2001, Mr. Byington is asking Mr. Costa to think about solutions for some unclear problem relating to Spectacular and the foreign companies. So it simply is not right for you to infer that the resignation in November 2000 of Mr. Costa terminated automatically and of itself the relationship between Mr. Byington and Mr. Costa, or indeed the authority of Mr. Costa to operate these overseas companies. And I simply make those points not to undermine the judge's decision at all, but to make the point that it cannot be suggested at 2 removes of appeal that this was a fraud in circumstances where Mr. Costa had simply flown the coop and then decided to use his residual powers to defraud his principal. Those are the 2 points I wanted to make in my canter over the factual scenario. I'm conscious that there ought to be an afternoon break, and I haven't calculated what time that should be. No?
No, Mr. Thompson, we have because the morning session's longer, we have a morning break, and unless anyone is needing an afternoon break because their eyesight is being stretched, then we just press on.
Okay, I'm very happy.
Are you content that we do that?
My lord, I'm in your hands. So I was going to touch upon, if I might, section 80 before going to the meat of the case dealing with the ostensible authority and the multinational gas point. You have in my written case in the bundle at page 2482 my more detailed submissions on section 80, which I don't intend to read out or précis today. I just wanted to make 2 points by reference to the documents in oral submission to support my submissions. And that is simply about the scope of what can be said about section 80 now. This is in the context, and without prejudice to my suggestion, the entire point is OTOs, because it can add nothing to Malone and Friends' case. But my point is this. Malone Friend says in his case, and has said in his oral submissions, that his case is that there was a tortious duty that fell upon the respondents to ensure compliance with section 80. I wanted to take your lordships and ladyships to the way this point was pleaded, which is at page 818 of the record, which is again in the amended statement of case. It's quite a discursive section of the statement of claim, not a charge I can lay upon Mr. Hubble, but paragraph 4.11 is dealing with section 80 of the IBC. And as you can see, the first sentence simply identifies the statutory obligations, and the second sentence, starting 5 lines down, explains that section 80, at least alleges, section 80 imposed a mandatory duty upon the director of Spectacular to approve the proposed sale, and B, to put such approval to the members of Spectacular for a members' resolution ratifying the same. And then there's an explanation of the nature of the obligations. And two things to make, 2 points to make about this. Firstly, it is suggested here that the duty relates to the sale. And the second is, it is not put as a tortious duty to ensure that the company does this. It is put as a mandatory duty on the director to put that approval to a resolution. Now, the reason this matters is because of the lateness of timing of this claim. If you recall, this claim was brought on the 6th anniversary of the signing of the agreement for the sale of land in Brazil. So the claim was issued on the 14th of December 2007. That means any breach of contract which was alleged to have taken place at the point when the power of attorney was executed, was time barred. It also means any claim based upon a breach of duty which occurred or accrued prior to the 14th of December 2001 is also time barred. That point, if it isn't clear on the case, was in fact ordered by the court in a consent order that your lordships and ladyships have at page 888. The claims for breach of contract were dismissed by consent in paragraph 1, and over the page at 889, the court ordered, if and insofar as it can be said, it be noted the claimant contends it cannot be said, that any cause of action pursued by the claimant in reliance on section 80 of the IBC accrued prior to 14th of December, then any claim in respect of such action is statute barred. So the only allegation which could be run is that there was some breach of section 80 on or after the 14th of December 2001. And as that was the day when the sale was actually executed, not completed, but certainly signed, it is hard to see what action it is, or even what omission it said took place that gives rise to the cause of action. Obviously, the power of attorney having been granted to Mr. DeLollo, it was within his power, ex hypothesi, to effect the sale. You can't grant a power of attorney with one hand and then say on the other hand, well, you can't execute it without coming back and asking for my approval. So, as a matter of law, I would submit the Section 80 claim simply cannot run. And the solution Mr. Hubble has come up with, which is to say it's a tortious claim that only arises when the loss is suffered, i.e. at the point of the sale, in my submission doesn't work, because there has to be, as it was alleged in the statement of claim, even on Spectacular's best case, some failure to seek approval of the member. That brings me to what I've identified as what I've called the heart of the submission. Sorry, my Lord Burrows.
Yes, can I just press you on that point? If one was to say that the duty, I mean, I'm not sure whether you're making a pleading point or a general point of law. If I was to press you as to the duty, how that duty is actionable, would it not most obviously be a tort action for breach of statutory duty, where one might expect that damage or loss is part of the cause of action? In other words, what are you saying the cause of action is for breach of Section 80?
It's to answer your first parenthetic point. It's more a pleading point than a legal point that I'm making here. It is simply the case that the way the case was pleaded in the first instance was that there was a mandatory duty that fell upon the director to seek that approval. And in my submission, for that to work as a claim, then that would have to be done at the time when the effective wrong occurred, which is on the claimant's case when the power of attorney was granted. My point really is limited to the idea that the sale itself was something which was already beyond the power of the directors to control or limit or restrict as soon as the power of attorney had been granted.
So you're saying the damage occurs, the loss occurs with the granting of the power of the attorney?
Well, it's yes, I am saying that. I mean, you might not be able to quantify it, and of course, it is still contingent on the unproven point about it being at an undervalue. But if there is a breach of that duty, firstly, in my submission, it really only can be made as a claim, as a failure to obtain that approval. That is what the statute of duty requires, and that must be done at the last moment, or must be done at the last possible opportunity when you had the power to do it. As soon as you've put it out of your power to have any control over the sale, then the duty the breach has occurred. I mean, my lord, the difficulty, I suppose, with it is that Section 80 on Mr. Hubbell's reading of it simply cannot be squared with a power of a BVI company to grant a power of attorney for sale of more than 50% of its property.
Thank you.
So I'll turn then to the two main submissions made by my learned friend, dealing firstly with ostensible authority and then with the geomatic or multinational gas point. And just to say, as a background to my submissions here, Mr. Hubbell's claim in the Court of Appeal and the thrust of his written case is about directors' duties. I don't see now from his submissions that is a point that is pursued with a great deal of vigour, save in so far as it is maintained to be a sort of backup point if the geomatic or multinational gas point is bad, or the point I'm making is bad on that. Let me put it another way. If the Court of Appeal was right about ostensible authority, and if it was right about geomatic and multinational gas, then in my submission, there simply isn't any space for argument about the duties of directors. And so, in my respectful submission, Mr. Hubbell is right to recharacterise the nature of this appeal as one which only really touches upon ostensible authority and multinational gas type decisions. In terms of ostensible authority, dealing with the way Mr. Hubbell put it, I accept, and indeed it was accepted at trial, that Mr. Costa didn't have the actual authority of Mr. Byington to effect the sale. And I accept also, as again it was accepted at trial, that Mr. Byington made no express representation to the respondents clothing Mr. Costa with his authority in that way. Of course, what this question really comes down to is whether the course of dealing is one which is sufficient to clothe Mr. Costa with ostensible authority. And really, it's the point that my Lady Black and my Lord Hodge were debating with Mr. Hubbell about whether the acquiescence, the silence, and the acceptance of all the steps that were done between 1997 and 2000 created the course of dealing that is sufficient to give Mr. Costa the clothing of an agent. As I've taken your lordships and ladyships through, you can see that Mr. Costa was intimately involved with everything from the setup of the company and the acquisition of the company through to the obtaining of the powers of attorneys, through to the payment of the fees and the directions of the invoices, and indeed as late as 2001, he was clearly advising, or his advice was being sought from Mr. Byington on questions related to Spectacular and the offshore companies. Indeed, there seems to be that suggestion in the last email I showed you. Mr. Byington didn't even know where Spectacular was located, probably may not even have been aware which offshore jurisdiction had been selected. In those circumstances, in my submission, it is entirely unsurprising that the judge came to the conclusion as he did, that Mr. Byington had arranged those matters so that those engaged on his behalf on the affairs of Spectacular were expected to act on the instructions of Mr. Costa. The answer to ostensible authority is, ironically, contained entirely in Justice Bannister's decision. Despite the fact that he concluded that ostensible authority wasn't a relevant principle to the case, he made all the factual findings essential to conclude that it was, in fact, the case that Mr. Costa had the ostensible authority of Mr. Byington in the eyes of the respondents. And so you only need to pick it up, as my Lord Legate pointed out, in paragraphs 50 and 51 of the judgment at page 2130 and 2131, to see that that Justice Bannister made all those conclusions about arrangements of matters, and it almost word for word captures what Lord Sumption had said in the Kelly and Fraser case. The phrase used by Lord Sumption and Kelly and Fraser was organised its affairs. What Justice Bannister said is arranged matters. Indistinguishable concepts. What has happened here is that Mr. Byington has arranged those matters so that Mr. Costa could act in that way. And that was indeed exactly what Mr. Byington wanted. It wasn't a mistake. This is precisely what he wanted, as you can see from the management agreement and the handwritten note. Mr. Byington was adamant that he'd remained in the shadows. This was precisely the system that he wanted to operate. He wanted his name off every document, even though he knew, he was told it wasn't going to be on the public record. He still didn't want his name there. He wanted bearer shares held not by himself, but by somebody else. And this is the context, as the judge found, that he was in the process of defrauding creditors. The first, second, third, and fourth powers of attorneys were all posted out to Mr. Costa. The fifth power of attorney, he asked to be posted to him, but then when he found the office was going to be closed, he asked it to be posted to Mr. DeLollo. Not to some hidden secret address, but Mr. DeLollo, the grantee of the power of attorney. In those circumstances, in my submission, it simply is unreal to suggest that there wasn't a course of dealing where Mr. Costa was clothed with ostensible authority. This is what he wanted. That was a system he'd set up. It operated for 4 years exactly as he wanted. He never complained about it. The fees were all paid. What was the reliance, Melania Fred says? Well, I did describe that maybe rudely in my case as being a laughable submission, but in my submission, there's nothing to this point. It's obvious that the respondents relied upon this. Firstly, they didn't repeatedly go back to Mr. Byington. Mr. Byington would have been appalled if he'd constantly been badgered by Citco, BVI, and Tortola, TCCL, with requests whether it was acceptable for Mr. Costa to this, that, and the other. No doubt he would have got very tetchy about that, given his desire for secrecy. But on reliance of this system, Citco simply dealt through Mr. Costa. And that was obviously somewhat easy for them. He's described various places as being quite easygoing. He obviously communicates quite well. All the bills are paid. That is the system which has been set up, which they rely upon. As for the put on inquiry point, the red flags, well, a few points here. Firstly, the judge dealt with the red flags as a matter of fact, and I have reiterated his findings in my case at paragraph 105, page 2480. And again, I'm not going to go through the red flags unless I'm invited to do so now. Can I deal with my Lady Arden's point about where in the judgment that is dealt with? Because obviously it is the case, it's paragraph 52 of the judgment at page 2131. It obviously is the case that Justice Bannister dealt with it under the heading of Citco BVI. But in my submission, that isn't determinative, or should not too much should be read into it. Firstly, the section on Citco BVI starts at paragraph 47, and Justice Bannister deals in 2 paragraphs with the point that there simply isn't any relevant contract between Citco and Spectacular, just the registered agent and the company, of which any breach could be alleged of. They didn't actually breach any of their duties as registered agent. That's unsurprising, as the duties of registered agent is very, very light indeed. All you've got to do is maintain the office, which in reality is often simply a manila folder in a filing cabinet. And so paragraph 49, the judge disposes of Spectacular's claim against Citco for breach of duty. But then he goes on in what is effectively an obiter section to deal with the various breaches pleaded. And paragraphs 50 through to 58 really are all about the breaches of duty as against Citco, if the judge is wrong that there are in fact those duties in the first place. And so you see under 50 and 51 this description of the arrangement that has been set up by Mr. Byington, and you see at 52 the point that 52 and 53 about the red flags. Now, those paragraphs are not repeated under the TCCL section starting at paragraph 59, but it's patently the case that the judge thinks that those systems that were set up are ones that are relevant across the board. He doesn't can't be read as saying, oh, well, that's a system for Citco, but it obviously was different for TCCL. So, with respect, the answer to my Lady Arden's point is that those findings about the arrangement of matters and the system and the reliance on his Mr. Costa's instructions are things of general importance that the judge finds and can indeed be read across to TCCL and indeed generally. They are general findings of fact that the judge was made, and the fact that they're under the heading of Citco BVI shouldn't be read as meaning that he didn't consider the point as a general issue.
Well, there is this difference, and I see what you say, but in relation to the duties of the registration agent, they're obviously quite limited and they're pretty ministerial. But when we get to a director, TCCL, the position is different. They obviously have fiduciary duties subject to the, this is something you're going to come on to, but let's say just to get on with it, that they are relieved from certain matters by shareholder consent, shareholder assent. But on that aspect, of course, they can only be relieved to the extent the shareholder has power to relieve them. And when you look at the 5th power of attorney, where nothing is said about the proceeds of sale, it might be said that it ought to have gone through TCCL's mind that actually it ought to ask a question about what's happening to the proceeds of sale, because it was not within the power of the shareholders to extract that from the company or to extract the assets, sell them for a single reel or whatever it was. So the fact that nothing was said about safekeeping, and I've got your point, well, Mr. De Lolo is a lawyer in Brazil, and therefore one must be expected to take into account his professional responsibilities. That doesn't quite answer the point, because he might well be instructed by the shareholder to pay the assets to who knows whom, but not to pay them back into the company. And no doubt this professional director, TCCL, did not want to be left as the director of an insolvent enterprise, which was wound up in the BVI, with questions being asked about what happened to the assets then. So just bearing those points in mind, and the limitations of shareholder assent, which you want to deal with, I know more fully. Could it be said that there is more a separate issue as to red flags in relation to TCCL, which not really dealt with by the judge?
My lady, I take the point, and it's obviously an important point that I had to deal with in relation to the powers that the shareholders and the members have to deal with the assets of the company, as your ladyship points out to me, which I'll deal with, if I may, under that particular heading.
All right.
I mean, I will simply say this for now. This is not a case, as it happens, where the company was left insolvent. Now, it might be said, this is putting Mr. Hubbell's case at its very highest. It might be said that what the directors did was rash, and that they ran that risk, because if in fact the transaction had been one which left it insolvent, then there might have been a breach of that rule. But this case obviously is brought in tort, as I've just shown you from that consent order. And so if there is no insolvency, there isn't going to be anything other than an inchoate course of action.
Okay, but we're dealing with the liability point, and we're not looking at any question of loss. So the question would be, was the professional director put on an inquiry to ask what was happening about the funds of the company and the assets, indeed the totality of the assets as we understand it. And so I don't know that we're really troubled about whether they were in fact misappropriated. We'd have to analyse what the duty was.
My lady,
coming on to it anyway.
I fully accept that point, and I'm not going to shy away from the fact that the judge didn't address it in those terms. My point on the reading of the judgment was simply to say that he made those findings in the context as applicable to both defendants as it was then. I would hesitate before inviting your ladyship to conclude that he made those findings vis-a-vis only one of the defendants. Now, your ladyship might take the view, and I will try and persuade you otherwise, that was an erroneous conclusion to draw vis-a-vis TCCL, even if it might have been a fair one to draw vis-a-vis Citco. And I take your ladyship's point, and I will, if I may, address that in due course when I come to that. But yes, as a point of law, obviously the two entities have different obligations, and there might be different things that they ought to be looking out for as red flags.
Thank you. Let's leave it there. Thank you.
One last point, if I may, on red flags, which is simply to address the point about the November 2001 communications. There were these communications which Manfred was taken to in 2001 for various formal documents that were sought from my clients at that point. In my submission, that doesn't add anything to Malone & Friends' case at all on the red flags point, because if there was something untoward in August 2001, contrary to my submissions, then that is the point when the authority would, if you like, have been negated, or rather when the respondents ought to have recognised that the ostensible authority was absent, following on Lord Kitchen's analysis in the Satria case. But by November 2001, that point has gone. It's too late. The power of attorney has been sent, and there's nothing further which is then brought to the respondent's attention, which could be said to question the bona fides or the authority of Mr. Costa at that point. That they are mere matters of formality. And actually, perhaps I can just take you back to Satria on this point, just to identify the factual disparity between that case and indeed most cases in this field and this one. At page 3443 of the bundle, you can see the section that Malone Friend took you to. Sorry, if you start at 3442, Malone Friend took you to this section dealing with being put on inquiry, paragraphs 92 and 93, and I won't read those again, but if you look at page 3443, paragraph 94, you can see the actual facts of that case and how it was on the facts of that case that that there also been a question about the authority of Mr. Jones in executing the sale, and the highly unusual features of the transaction in the middle of that paragraph were EACL selling its only asset, EACL simply being an intermediate holding company for AOL and Mr. Watabe, and no contact had been made with either Mr. Jones and Hatter had a financial interest in the transaction. Now, on this case, it will be said against me, well, it is the only assets of the company being sold, but it is true as a matter of fact that the respondents did not know that they were the only assets being sold, whereas in the Satcher case, they did. It's also a very different case here in that the agent in the Satcher case had a financial interest in the transaction. And in fact, one of the interesting features of the Satcher case is that the third party, in fact, had express knowledge of the documents and the powers of the company to execute these to execute the agreement, and knew that it wasn't open to a single director to do so, that the power to effect this transaction resided with the board. So it is very different in this case, where we're talking, of course, about the authority of Mr. Costa as agent of Mr. Byington. And it's important to bear in mind that we're not talking in this case about the question of an agent for a company. We're talking about the question of an agent for another human being, because Mr. Costa is, on this analysis, simply an agent for the sole ultimate beneficial owner of the company. He isn't acting on behalf of the company per se, he's acting on behalf of an individual. And so this isn't like the Satcher case, where the representee, if you like, is has some detailed understanding of the nature of the authority as a matter of fact. There was nothing that the respondents knew about the underlying factual authority that Mr. Byington had given to Mr. Costa. Mr. Hubble uses that against me, but it is in fact the case that all they knew was that this course of dealing had been set up and had been operated without demur for many years, with the obvious acquiescence of Mr. Byington. Now, if you are with me on this point about ostensible authority, then it is then the conclusion is that the instructions that Mr. Costa gave to the respondents were, as a matter of law, the instructions of Mr. Byington. And that is the case as a matter of law, whether or not Mr. Byington approved of them, and whether or not he would have approved of them if he had known. That is simply the consequence of the principle of ostensible authority. And at that point, all arguments about fraud fall away, because the principle of ostensible authority is there in order to strike a balance between a principal and a third party in circumstances where the agent is not actually authorized. So all questions of fraud will collapse if your lordships and ladyships are with me on the point about Mr. Costa and his ostensible authority. And that will leave only over to be decided the question about whether, in fact, Mr. Byington had the power under the principle in multinational gas to give the instructions to the director to execute that power of attorney. And so my submissions in relation to multinational gas, which, given the time I might save over for tomorrow, are simply going to be, in summary, this, that it isn't an extension of the geomatic principle to apply the general law of agency to the question. It is simply, as Lord Hoffman says, an application of the general law to the specific question of attribution. It's simply a way in which a shareholder of a company or a ultimate beneficial owner of a company is able to give his instructions as per the law of agency. And that being the case, it is wrong in my submission to imagine that you are being invited to extend in any way the law set down in geomatic or multinational gas. And the points that my learned friend makes about the cases where third parties are arguing about the attribution of some dishonest actor to a company are nothing to the point. So the Stone and Roll, Singularis and Bilter cases are nothing to the point, because those questions turn on their own complicated facts as to whether it is right in circumstances to attribute dishonest motives of dishonest actors to companies in circumstances where the rights of third parties are involved. This is not one of those cases. This case will simply collapse into one about whether, in fact, the member had the power to do to affect that power of attorney, and in particular to the question raised by my Lady Arden. It does not involve any greater extension of the principles than that. It's 2 minutes to 4. My Lord Hodger, I hesitate before starting the last topic, which I won't be able to finish in 2 minutes or even 10. So might now be a convenient moment.
Yes, indeed. If it suits you, you're in good time, are you, to complete your submissions within the allotted time?
I think I have allocated to me more than an hour tomorrow, and I'd be very surprised if I had more than half an hour.
Well, you have allocated you, I think, technically till 12:15 formally, but given the events of today, till 12:25.
Yes, well, as long as I'm not missing any points that your lordships and ladyships think I ought to be addressing that are set out in my case, then I wouldn't expect to be much more than half an hour.
Well, on that basis, the board will adjourn till tomorrow morning. Thank you both very much.
I'm very grateful.